Hi friend, welcome to the Company Law Adjudication and Appeal series. Today we are discussing Madhya Pradesh ROC adjudication order for the violation of section 203 by a listed company which is required to appoint a whole-time company secretary at the time of the listing in the stock exchange. Let's see the facts of the case. Company name is the Sisto Tele Link Limited, having registered office at Indore, Madhya Pradesh. And as per the MCA record, company is a public company and not a small company. And as per the legal requirement of section 203 subsection 1, every company belonging to the such class or classes of company as may be prescribed shall have whole time KMP. And further, section 203 subsection 4 says that if any office of any whole-time KMP is vacated, the resulting company shall be filled up by the board at a meeting of the board within the period of 6 months from the date of such vacancy. And Rule 8 says Rule 8 of the company's appointment and remuneration of managerial personnel says that every listed company and every other public company having a paid up share capital of the 10 crore rupees or more shall have whole time KMP. In the as per the records of the MCA, company is the listed company. Company's stocks are listed on a specified date, and at the time of the listing, company has not appointed a company secretary. And let's see the facts of the case. As per the inquiry conducted by this ROC office under section 206 subsection 4 of the Companies Act, it was found that as per the section 203 read with the rule 8 of the company's appointment and remuneration of managerial personnel rules, every listed company is required to appoint a company secretary in the board of directors. But the company has appointed company secretary on 20th November 2018, while company was to appoint at the time when the company was listed at the stock exchange. Thus, it appears that the company and its officer in default has violated section 203, subsection 1 of the Companies Act and attacked penal provision under section 203, subsection 5 of the Companies Act. Here the period is the 2nd November 2018 to 20th November 2018 only for 18 days default. Accordingly, this office had issued so-called notice to the company and its officer in default. However, no reply has been submitted from the company and its director till date. Thereafter, notice of inquiry were issued to the company and its officer who is in default, and the date of the hearing the company has taken extension, and after next hearing, company and director submitted their reply to this office, and authorized representative present at the meeting, and the matter is being proceeded. Accordingly, the penalty provision for violation, that the section non-compliance of section 203 subsection 1 would result in penal action under section 203 subsection 5, and as per subsection 5 of section 203, in case of the default of this section, company shall be liable to pay to penalty of 5 lakh rupees, and every director and KMP who is in default shall be liable to penalty of 50,000 rupees, and where default continuing one with further penalty of 1,000 rupees for each day. And the subject company does not cover under the preview of a small company, hence the section 446B would not be applicable on the company. And in this order, having considered the facts and circumstances of the case and after taking into account the factors above, it is concluded that the company and its officer in default are liable for penalty as prescribed under section 203 subsection 5 for default in made complying with the requirement of section 203 subsection 1 with read with the rule 8. For the period, here period is calculated from the for 18 days from the 2nd November 2018, that is at the time of the listing, to 20th November 2018. Accordingly, ROC imposed a penalty on the company. That is the 5 lakh. Here is the 5 lakh or 1,000 per day for 18 days, that is 5,18,000, but maximum penalty imposed under this section is 5 lakh, that is imposed on the company. And official in default 50,000 on official in default. Whole time director is the considered as the officer in default, and 18 days default 18,000, the 68,000 total penalty imposed here. And here, and accordingly the company and officer who is default are directed to pay the penalty amount as calculated in table, and this penalty amount is the commensurate with the aforesaid failure committed by the notice and noticee, and penalty so imposed upon opposition default shall be paid from their personal source of income. This is the latest update from the MCA side. Thank you so much for watching this appeal adjudication order. Thank you.